How will the bank know I've passed away, and what happens next? 1. The moment everything freezes. When someone dies with a bank account in their sole name, the account doesn't quietly keep running, it locks up. Banks are not clairvoyant, but they have systems that eventually find out. Social Security stops depositing checks. Automatic payments bounce. Sometimes a family member, well-meaning and grief-stricken, walks into the branch with a death certificate. The teller smiles politely and says, "Thank you for letting us know," while mentally typing the word freeze. So what does that actually mean? It means no one can touch that money, not family, not heirs, until the court says who gets it. The result: bills go unpaid, deposits reverse, and the estate begins its long march through probate. Footnote: banks freeze sole owner accounts immediately upon notice of death, pending a court order or estate authorization. 2. The small estate illusion. People often shrug it off, it's only a few $1,000s. But probate doesn't care about your opinion of small. Each state sets its own threshold for a small estate, often around $75,000, and in some states like New York, as low as $50,000. If your total estate value crosses that line, even by a little, your heirs face the full legal process. So what does that actually mean? It means even a modest checking account can trigger a court case if the estate crosses the threshold. Footnote: small estate limits vary by state, exceeding them requires probate regardless of account balance. 3. Joint accounts, better, but not foolproof. Adding a spouse to your account as joint tenant with rights of survivorship helps. If one dies, the other keeps access. But that safety net has holes. What if both joint owners die together, or within days of each other? No names left on the account means the same old ending: probate. So what does that actually mean? It means joint ownership works, until it doesn't. Footnote: joint tenancy provides immediate survivorship but fails when all named owners predecease or die simultaneously. 4. 2 ways out: how to dodge probate entirely. There are only 2 reliable escape routes from probate. A. Retitle the asset into a revocable living trust, or B. Add a designated beneficiary to receive it directly upon death. Both let you keep full control while you're alive and skip the courthouse later. But each comes with trade-offs. Footnote: trust ownership and beneficiary designations are the 2 primary non-probate transfer mechanisms under U.S. law. 5. The trust route: flexibility with friction. A revocable living trust gives you power and precision. You can decide how and when your heirs receive funds, gradually, at milestones, or not at all if they're minors or financially reckless. You can even condition distributions on education or sobriety. But some banks still treat trust accounts like aliens from another planet. Opening, transferring, and even linking payroll or online deposits can involve extra paperwork and compliance hurdles. Direct deposits and digital transfers may be rejected or delayed. So what does that actually mean? It means total control sometimes comes with total bureaucracy. Footnote: trust-titled accounts offer flexible estate control but may encounter operational restrictions with financial institutions. 6. The payable on death route: simple, fast, and risky. Adding a payable on death (POD) designation is easy: no lawyers, no new account, no interruptions. You keep full access, the bank adds one form. When you die, the funds flow directly to your named beneficiaries. But simplicity has a dark side. The money goes out in one giant lump sum, no conditions, no timing, no protection from bad decisions or creditors. If your heirs are young or impulsive, you've just handed them a financial grenade. So what does that actually mean? It means POD accounts skip the courtroom, but they also skip your judgment. Footnote: payable on death accounts bypass probate but provide no control over timing, use, or creditor protection for beneficiaries. 7. The hybrid strategy, best of both worlds. One clever solution is to keep two accounts: personal account, your everyday checking with a POD designation for immediate liquidity to heirs. Trust account, a secondary account titled under your revocable trust, holding larger reserves subject to your detailed rules. The personal account stays nimble, the trust account enforces discipline. Together, they combine flexibility in life with protection in death. So what does that actually mean? It means you can design a system that works now and later, without giving up convenience. Footnote: combining POD and trust structures balances operational simplicity with post-death control and protection. 8. The hidden landmine, outdated beneficiaries. Beneficiary designations can go stale fast. A death, divorce, or incapacity among named heirs can throw the bank into confusion. When banks face uncertainty, they default to one action: freeze everything. So what does that actually mean? It means the best estate plan in the world fails if the paperwork isn't current. Footnote: outdated or incapacitated beneficiary designations can invalidate automatic transfers, forcing the account into probate.